Today, let's discuss an often overlooked but incredibly important aspect of financial and personal security: proper estate planning and regular updates. My name is Leon Jones Jr., and I am the managing attorney here at Big Rock Legacy Law Group. Even though it is a myth that most people do believe, estate planning is not just for the wealthy or the elderly. It is for anyone who wants to ensure their loved ones are taken care of after they're gone. Unfortunately, many people either delay the estate planning process or assume that once their documents are prepared, their job is done. However, failing to regularly update your estate plan documents can lead to significant legal, financial, and often emotional stress for your family. Now, before we dive into the importance of updates, let's first talk about why proper estate planning does matter, especially in avoiding probate. Now, as we know, probate is a court-supervised process for distributing your assets after you pass. It can be time-consuming, costly, and stressful to your heirs. But with proper estate planning, we can ensure that assets are transferred efficiently, reducing or even eliminating the need for probate. So call us today and set up your legal strategy session, and we will discuss in more detail how and why. But for now, here are 3 quick ways to start the planning process. Number 1, have a clear, legally valid will that directs your assets, how they should be distributed. But even better than that, let's establish a trust that can avoid probate altogether by ensuring your assets transfer automatically to your beneficiaries. Number 2, assets like life insurance policy, retirement accounts, and payable on death bank accounts can pass directly to your designated beneficiaries without the probate process. And lastly, let's make sure your financial accounts are titled as joint ownership and establishing transfer on death or beneficiary deeds, which are tools to allow property and accounts to transfer automatically to a co-owner or named beneficiary. Now, once you have these documents in place, then what happens if your will, trust, or beneficiary designation no longer reflect your current circumstances? Well, that's where regular updates come in, and scheduling a legal strategy session with us here at Big Rock Legacy Law Group today is the first step. Life is constantly changing, and estate plans should evolve accordingly. Failing to update your documents can create unintended complications, such as assets going to the wrong people, increased taxes, or even unnecessary legal disputes. So here's some key life events that we should all keep in mind that will prompt us to review: marriage or divorce. If you get married or if you get divorced, your estate plan must reflect your new status to ensure assets go where they're intended: births or adoptions of children or grandchildren. If you want to provide for a new family member, updating your will or trust ensures that they are included. And death of a beneficiary or executor. If a named heir or executor passes, then your documents must be updated to reflect the new choices that you made. Significant financial changes. Whether you accumulate new wealth, whether you sold a business, face financial hardship, your estate plan should be adjusted accordingly. And relocation to a new state. Estate laws vary by state, and moving could require changes to ensure your estate plan remains valid and effective. And there are also tax law changes to be aware of. Government policies regarding estate and inherited taxes changes over time, and your plan should adopt to minimize those tax liabilities. Let me give you a few real-world examples of why regular updates do matter. A former spouse inherits everything. Imagine someone you created a will with 20 years ago, leaving everything to that spouse. And after the divorce, they remarried, but never updated their estate plan documents. Upon passing, their ex-spouse, not their current spouse, inherits everything. An unintended guardian for your children. If parents fail to name a legal guardian for their minor children, the court will decide, possibly choosing someone you don't want to oversee your children. And then legal battles among family members. Without clear, updated documents, disputes will arise, leading to costly legal battles that could have avoidable consequences. So to prevent these situations, I strongly recommend that you reviewing your estate plan at least every 3 to 5 years and whenever major life changes occur. So work with us here at Big Rock to ensure your documents are up to date and aligned with your wishes. Now, estate planning isn't just about drafting documents. It's about keeping them current to protect your loved ones and ensure your legacy is handled smoothly. The last thing you want is for a family member to deal with legal complications during an already difficult time. By staying proactive, reviewing your estate plan regularly, and making necessary updates, you can spare your heirs from unnecessary court proceedings, financial losses, and family disputes. So if you haven't reviewed your estate plan recently, let us be here to remind you. Call us now, schedule a legal strategy session to safeguard your future and that of your loved ones.